Jefferson County Court Law number 2 is in session. The court is in session in cause number 25 CCCR 1602 case of style of the state of Texas versus Kason Mitchell Christopher. Mr. Christopher, is that your full name?
Yes, sir.
Okay, Mr. Christopher, you have a felony case that's occurred on the same day of this misdemeanor. Your felony case was reset and your misdemeanor cases will be reset on the same day.
Yes, sir.
Okay, now the court needs to give you some bond conditions. Okay, I'm gonna hand these bond conditions to your attorney. He will hand them to you. And the document is titled Standard Bond Conditions in County Court Law number 2. Do you see that title?
Sir.
Okay, and it states, following the return of a criminal information in County Court Law number 2, all bail bonds are executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3 does not apply. Condition number 4 does not apply. However, condition number 5 does apply. Condition number 5 states that the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer, as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Now, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Now, this will conclude your case. Please stay in contact with your attorney and your bondsman. You're free to go. And you have a blessed day. Mr. Nix, you're free to go as well.
Thank you, Judge. See you on November 18th.
All right, thank you. And Miss Mosby, you could, we're gonna get started on the arraignment.
How did he last?
He's gonna go over all the paperwork. You all can wait to fill it out. This is one we're talking about. Whatever. They got one. Be responsible. They get paid the big money for that. I still smell it. Yeah. Can you remember to call to see if they did come? They said they still smell it. Hey.
I really like that this guy thing needs to be on the scene.
All rise. County Court running to its now in session. I'm addressing your side.
You may be seated. Hmm. Okay, good morning, ladies and gentlemen. I'd like to welcome you to the County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. This morning, we have what is called an arraignment, and what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning the case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Now, your felony cases are normally referred to as your most serious type of criminal offenses, whereas your misdemeanor cases are normally referred to as a petty offense. Does not mean that they're not serious. It just means that they're not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case and a possible punishment that a person can receive if they are convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top and work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and state jail felony. Now, if a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. Now, if a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years or life in the state penitentiary, and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned to you earlier, your case is a misdemeanor criminal case, so you don't have to worry about those type of punishment. However, misdemeanor cases are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, Class B misdemeanor, and the Class C misdemeanor. Class C misdemeanors are cases that start in the JP court or the city court, the municipal court. Now, they come to this court when a person is found guilty in the municipal court or the JP court, and then they appeal their case. In essence, they're asking for a new trial. They get a whole new trial. And the case comes up to this court, and the range of punishment stays the same. Now, the range of punishment for a Class C misdemeanor is a fine that cannot exceed $500. You cannot be given jail time. It's a fine that cannot exceed $500. However, if you fail to pay the fine, or if your fine was converted to community service and you failed to perform the community service, then the court or the judge can issue what is called a capias pro fine. That simply means it's a warrant for your arrest to either pay the fine or sit the fine out in jail. Now, if you sit the fine out in jail, you'll be credited at $100 for every 1 day that you spend in the county jail. Now, the next highest misdemeanor is a Class B misdemeanor. Now, with the Class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days in the county jail, or you could be given a fine that does not exceed $2,000, or you could be given both such jail time and a fine. Now, the highest misdemeanor is a Class A misdemeanor. And the range of punishment for a Class A misdemeanor is minimum 0 days to a maximum of 365 days, which is a year in the county jail, or you could be given a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, you may be eligible for probation. There are two types of probation. One type of probation is called unadjudicated probation. We commonly refer to it as deferred probation. With the unadjudicated probation, it does not result in a conviction on your record. And if you successfully complete that type of probation, the case will be dismissed. You will not have a conviction on your record, and you may qualify for what is called a non-disclosure. A non-disclosure just simply means that your record will be sealed to the general public. Now, the operative word that I use is general public. That simply means that the government or certain agencies that are listed in the Texas Code of Criminal Procedure can't have access, but most of the public is the general public, so most of the public cannot have access to it. So, for example, let's say you apply for a job at ExxonMobil, and they're part of the general public. They're not a state agency or governmental agency. They cannot have access to the case, because if you receive a non-disclosure. Now, the next highest misdemeanor, the next type of probation rather is adjudicated probation. We commonly refer to it as regular probation. Now, with the adjudicated probation, it does result in a conviction of your record. However, there is something that is called judicial clemency. That simply means that the court can set aside your conviction. That is, the judge can set your conviction aside, and you will no longer have a conviction. And in order to qualify for the judicial clemency, 3 things has to happen. Number 1, you have to successfully complete the probation. Number 2, there cannot be any more time left on the probation. And number 3, you have to successfully complete the probation and be discharged off the probation by the probation department. If those 3 things happen, you may qualify for judicial clemency. Now, however, if you get a subsequent conviction, that is, if you get another conviction later on after you receive judicial clemency on this case, then the case that you receive judicial clemency on can be resurrected, it can be brought back up, it can be revived, and it can be used against you. And if you try to get a license through Child Protective Services, then they could either deny giving you a license, or if you have a license, they can revoke or suspend that license. Okay. Now, everyone that's here for a case in this court, you should have a clipboard. And I'm getting ready to go over that clipboard, the information on that clipboard, which now behind the short sheet, there should be a sheet that's titled, the first sheet should be titled Judge's Explanation of Defendant's Right. It should be titled Judge's Explanation of Rights to Defendants Without Attorney. It looks like this. Okay, and get ready to go over this document. And we're gonna constantly refer to this document because before you leave here this morning, everybody's going to read and initial one of the lines at the bottom and you're gonna sign. Okay, so it states, the first thing, as a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you want an attorney and you can afford to hire an attorney, well, if you can't afford to hire an attorney, then you may ask for a court-appointed attorney. And number three, you may represent yourself. That is, if you would like to represent yourself, that is, you would like to waive your right to have an attorney, you have a right to represent yourself. Now, the first one sentence paragraph below number 3 states that if you want an attorney, you have enough money to hire an attorney, your case will be reset. Reset means that you will be given another court date from today to give you time to hire your attorney. The next paragraph states that if you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you, but you must first fill out a financial questionnaire. Now, the financial questionnaire is also on that clipboard. It is a 3-page document, probably should be the next page. It should be titled Affidavit of Injuries or Jefferson County Affidavit of Injuries. It's a 3-page document. Now, it should be titled Jefferson County Affidavit of Injuries. Keep turning to the next page. There it is. All right. Now, on that document, this is only for people who will be applying for a court-appointed attorney. If you're not applying for a court-appointed attorney, you don't have to worry about that document. But if you are applying for a court-appointed attorney, you need to fill out the first page of that document and then turn to the second page. On the second page, let's see, I think some of y'all second pages are actually the third. How many pages? Go to the next page. Okay, it's that page. It should be a page that's titled Defendant's Oath. Okay, it should be Defendant's Oath is at the top. You're gonna fill out the first, you're gonna fill out the top of that document, and where it says Defendant's Oath, and then you're gonna go to the middle portion, and it should be in brackets, that's titled Unsworn Declaration by a Defendant. Let's see what you have.
I don't know,
Go back,
I
okay,
think that's the one from
go back a page,
last week, Judge.
yeah, go back a page,
Change.
that page right there. You're gonna fill out the top part is in brackets, that's titled Defendant's Oath. And then the second part that says Unsworn Declaration by a Defendant. And then you'll stop, all right? Now, let's go back to that first document, Judge's Explanation of Rights to Defendants Without an Attorney. And the next paragraph below number 3 is the third paragraph below number 3, the third one sentence paragraph. It states that you may not speak to a prosecutor about your case unless you first sign a waiver of your right to have an attorney. Now, that is only for people who will be representing themselves. That's what that paragraph is talking about. For example, if you represent yourself, that means that you're waiving your right to have an attorney. You will be your own attorney. And because you are your own attorney, you'll have a right to talk to the prosecutors. Now, we have 2 prosecutors in court. They are assistant criminal district attorneys, work for the Jefferson County District Attorney's Office. You will have a right to talk. You know why? Because you're your own attorney. Just like the lawyer can talk to them, you can talk to them because you're your own attorney. Okay, but you cannot speak to them about your case unless you first sign a waiver of your right to have an attorney. Now, this is only for people who will be representing themselves. If you're not representing yourself, you don't have to worry about what I'm saying. Now, for those who will be representing themselves, you would have to sign a 1-page document that is also on the clipboard that is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding to Trial. That is only for people who would be representing themselves. If you're not representing yourself, you do not have to read that. Okay, you don't have to waste your time to read it. Okay? You would read it, sign it, and that's it. Now, let's go back to the first document. There is a document, there is a paragraph, it's in block form, second to the last paragraph. That is for people who will be representing themselves. It states that there are dangers and disadvantages of self-representation. Waiving your right to the attorney and representing yourself may result in the worst outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. And the last one sentence paragraph at the bottom of that first document states that if you are representing yourself, you may change your mind at any time and request that an attorney be appointed to represent you. Okay, so that just simply means that if you would like to represent yourself, and let's say you are representing yourself and you decide that, well, I'm gonna represent myself, I wanna see if I can work out a plea bargain with the state to settle my case, and I want deferred adjudication, I wanna see if they're gonna offer me deferred adjudication. Talk to the prosecutor says, well, we're gonna offer you jail time. And you say, well, I don't want that. Then you can say, well, judge, I changed my mind. I don't want to represent myself. I want to apply for a court-appointed attorney. You can do it. All right. Now, at the bottom of that document, that first document that we went over, at the bottom in bold letters, it states, defendant's choice, mark initials next to only one choice. Everybody here is going to make a choice. If you are going to hire your own attorney, you will place your initials on the first line to the left. At the bottom of that document.
Wonder if you're not sure you're gonna have one.
There's 5 choices, okay? Only if you're going to hire, if you think that you're going to hire an attorney, you'll place your initials on the first line to the left. And then you'll sign the bottom of the document that states defendant, and then you'll date it today's date, October 28th of 2025. Now, if you have already hired an attorney, then you'll place your initials on the second line to the left. And the name of the attorney on the line to the right. Okay? And then you'll sign at the bottom where it says defendant, and you will date it today's date, October 28th, 2025. If you would like to apply for a court-appointed attorney, then you'll place your initials on the third line to the left, sign the bottom of the document, where it says defendant, dated, and then you would have to fill out the financial questionnaire, first page of the financial questionnaire, and then you go to the next page where it has defendant's oath, where it's in brackets, you fill that out, and then you go to the bottom part that's titled unsworn declaration by defendant, fill that out, and then you'll stop. If you have already been appointed a court-appointed attorney in this case, then you'll put your initials on the fourth line to the left, the name of the attorney on the line to the right. Then you will sign at the bottom where it says defendant and dated, and then you'll stop. Now, if you would like to waive your right to an attorney, that is, you would like to represent yourself, then you'll place your initials on the fifth line to the left, and then you'll sign where it says defendant, you will date it today's date, and then you'll fill out the form that is titled waiver of counsel for purposes of entering a guilty plea or proceeding to trial. You'd have to read and sign that document, and then you will stop. Okay. We have any questions? Any questions?
I do.
Okay, what's your question?
I wonder if I said I want to reset the case and hire my attorney.
Okay.
I wonder if I find out I can't afford the attorney after I talk to him.
Well, you're gonna have a court date, you'll tell us that when you get back.
I'll have one now. So
You'll have, once you're, okay, it states that if you want to hire an attorney, your case will be reset. Reset means you'll be given another court date to give you time to hire an attorney. When you come back on that next court date, you can tell the court, well, Judge, I tried to hire an attorney, I can't afford to hire an attorney, I'd like to apply for a court-appointed attorney. You can do that. It doesn't prevent you from doing that. Okay, you can change your mind. If you can't, you don't know whether or not you can afford an attorney or not. You may or may not be able to. I don't know. Okay, any other questions? No, okay. All right, now, we're gonna give you time to fill out that paperwork. I need to go over some rights, some other rights that you have. Now, another right that you have is a right to have a trial by jury. Well, first, before I get into your right to have a trial by jury, let me tell you this. You can enter one of three types of pleas. That's the answer you're telling the court. You can enter a plea of not guilty. If you tell the court that you're not guilty, you're telling the court that you did not commit the offense that you've been charged with. Or you can enter a plea of guilty. If you enter a plea of guilty, you're telling the court that you committed the offense that you've been charged with. Or you can enter a plea of no contest. No contest means that you're not fighting or you're not contesting the charges. Now, you have a right to have a trial by jury. You want to go to trial. Where those young people are sitting in that area, we call that the jury box. 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to all of the evidence that's presented by the state and the defense. They will listen to the arguments of the state and the defense. And then they will go into the jury room to deliberate and to decide whether to find you not guilty or guilty. You can waive or give up your right to have a trial by jury. That simply means that you will not be having a trial by jury. Now, if you still want a trial, you still can have a trial. It's a trial without a jury. We call that a bench trial. It's a trial by judge, where the judge will be the judge and the jury in the case. The judge will listen to all of the evidence that's presented by the state and the defense. We listen to the arguments of the state and the defense. And then the judge will apply the facts to the law and decide whether to find you not guilty or guilty. Now, you also have a right to plead guilty or no contest. And if you do such, then you're saying that you want to see if you can work out a plea bargain, a settlement on your case. That's what a plea bargain is, a settlement on your case with the state. If you agree to settle your case, we call that an agreed plea bargain. Now, for example, let's say you want deferred probation. And let's say the state is not offering you deferred probation. And then you say, well, judge, since the state is not offering deferred probation, I take back my plea of guilty or no contest. You have a right to do that. That means that the law says you have a right to withdraw or take back your plea. All right? Now, let's say the state did offer you deferred. And you say, well, that's what I want. I accept. That's what I want. And so then once you and the state have come to an agreement, then it goes before the judge. The judge can do one of two things. The judge can accept your plea bargain agreement or reject your plea bargain agreement. Now, if the judge accepts your plea bargain agreement, and if you decide to say within 30 days that, you know what, I think I've been wrongfully convicted or the court committed an error by convicting me, I'd like to appeal my case. You have to get permission from the judge that followed the plea bargain agreement to appeal your case. Now, if the judge gives you that permission to appeal your case will leave this court and will go to the Ninth Court of Appeals. They're located right above us on the 3rd floor. There are 4 judges up there. They will review your case and they will decide. They can do one of two things. They can accept, they can grant or deny your appeal. If they grant you appeal, they can just simply find you not guilty and the case is over. Or they can send the case back down to this court with orders. Or if they reject your appeal, you can appeal it to a higher court than a Ninth Court of Appeals. You can appeal it to the highest criminal court in the state of Texas, located in Austin, Texas. It's called the Texas Court of Criminal Appeals. Now, you'd have to file what is called a pro se petition for discretionary review. I'll explain it to you. Pro se means you represent yourself. You don't have a lawyer, you're doing it on your own. Okay? And you're petitioning them to see whether or not your appeal should have been granted, or whether or not this court wrongfully convicted you or committed error by convicting you. They can do one of two things. They can grant or deny your petition. If they grant your petition, they can simply find you not guilty and the case is over. Or they can send the case back up to the Ninth Court of Appeals, or they can send it back down to this court with orders. Okay, both courts, if they send it up, they can send it to the Ninth Court of Appeals with orders as well. Okay, now if they deny your petition at that point, your conviction will stand. Okay, now if you and the state have not been able to reach an agreement, okay, y'all haven't been able to reach an agreement, but you still would like to see if a plea bargain can be worked out. Okay, what happens is this: we call it an unagreed plea bargain. You and the state have not been able to reach an agreement. No, that's unagreed. And so then it goes to the judge. And the judge will decide what your punishment will be. Okay? Anyone within the punishment range, anyone within probation, jail time and fine, or probation, unadjudicated probation, or adjudicated probation. So the judge will decide. That's an unagreed plea bargain. Okay. Now, the other right that you have is a right to have witnesses to come to court. They sit in that chair that I'm pointing at. It's called the witness stand. And what witnesses would do, they either can testify for you or against you. If you're representing yourself, you could ask some questions. Or if you have a lawyer, your lawyer could ask some questions. We call that either direct examination or cross-examination. Now, you can waive or give up your right to have witnesses to come to court. What that means is you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because they will be calling witnesses in that case. Now, you also have what is called a Fifth Amendment right against self-incrimination. What that means is this: the United States Constitution, or the Fifth Amendment of the United States Constitution, gives us a right to remain silent. So we do not incriminate ourselves. Okay? It's called the Fifth Amendment right against self-incrimination. What that means is this here: the state, the government, the district attorney's office cannot call you to take the witness stand. Right? If you exercise and invoke your Fifth Amendment right against self-incrimination, they can't force you to take the witness stand. And if you think about it, it makes sense. Because first of all, the state has the burden of proof. What that means is this: they have the burden to prove that you are guilty of the charge beyond a reasonable doubt. You don't have to prove yourself guilty. Okay? Doesn't make sense. And so you have a Fifth Amendment right against self-incrimination. You don't have to say anything. All right. Now, I know a lot of times we watch television like Law, and we see shows like Law and Order, and we see the television lawyer will go up to the witness stand and ask the witness a question, and the witness say, "I take the fifth." What he's saying is, I'm exercising my Fifth Amendment right against self-incrimination. I'm not saying anything. Okay? And so we all have that right. Now, the other thing that we need to talk about is you have a right to have what is called discovery. Discovery means you have a right to see the evidence or have access to the evidence that the state has and will be using against you in your case. Okay? That is, you have a right to see witness statements, your statements, police reports, lab reports, photos, video recordings, right to listen to audio recordings, right to have access to documents, history, whatever they have, whatever evidence that they have, you have a right to have access to that. Now, you also have a right to waive or give up the right to have discovery, which means that you're saying that I don't want to have access to it. Okay, all right. Now, everyone that's here, charges have been filed against you, you've been arrested, placed in the Jefferson County Jail, and you bonded out of jail. You eat out of jail on a cash bond, which means you pay the full amount of the bond to get out of jail. You're out of jail on a surety bond, which means you pay the bondsman a percentage of a bond to get out of jail. Or you're out of jail on what we call a PR bond or a personal recognizance bond, which means you didn't have to pay any money to get out of jail. You were released under your own personal recognizance. Now, I've said that to say this. Every day that you spent in jail can be used as credit towards your punishment. So, for example, the operative word is every day. Okay? Now, that simply means every day you get credit for it. So, for example, let's say you were booked into jail at 11:59 p.m. on last night, and you booked out of jail at 12:01 a.m. this morning, which means you were in jail 2 minutes. But you get 2 days credit. Why? Because it's 2 different days. It's not 48 hours. It's just 2 different days. And so you get 2 days credit. Now, let's say you spent 5 days in jail, state is offering you talk to the state, they're offering you to serve 5 days in jail. That simply means you don't have to serve any more time in jail. Why? Because you've been given credit for the time that you've already served. Now, if they're offering 7 days in jail, that means that you would only have to serve 2 days in jail because you already have credit for 5. We subtract 5 from 7, that leaves 2. Now, let's say the state is offering, the state is offering you a fine in court costs. Now, every day that you spend in jail, you are credited $100 per day. So if you spend 5 days in jail, that's $500 credit that can be used towards your fine and your court costs. So, for example, if the state is offering fine and court costs of $500, you spend 5 days in jail, that's $500. You won't have to pay anything. Why? Because the 5 days that you spent in jail has already paid it off. Therefore, it will be taxed and retired. Now, if the state is offering $700, you spend 5 days in jail, which is $500, that means you would have to pay $200. Because you already have $500 credit that's subtracted from the $700, that leaves $200. You'll be required to pay the $200 on the day that the case is disposed of. If you cannot pay it, no problem, because we could put you on what is called a payment plan where you could pay off small monthly installments until it's paid off. Now, let's say you still be unable to pay it because you do not have the income to pay it, no problem. We can convert your fine and court costs to community service. And for every 1 hour of community service that you perform at a nonprofit organization, Jefferson County, you will receive $12.50 credit towards your fine and court costs. So, for example, if you work 8 hours one day of community service, that's $100. That can be credited towards your fine and court costs. So in our scenario, you're $200, you just work 16 hours or 2 8-hour days. That's $200, and then your fine and court cost is paid off. Now, Jefferson County has a program for individuals who have not been in trouble before. When I use the term in trouble, I'm saying when cases are filed against you. If this is your first time, the district attorney's office has a program that's called pretrial diversion, whereby they will dismiss the case. And if you successfully complete the program, you can get an expunge, which means remove, erase, or delete it from your record. And the program is called pretrial diversion for first-time offenders. Now, in order to qualify for the program, it has to be your first time getting in trouble or getting cases filed against you. And then two, it cannot be front office involving unlawfully carrying weapon or resisting arrest. And three, you have to have an attorney to assist you in getting in the program. The attorney could be a court appointed attorney. Don't have to be one that you hire. Just any attorney who will assist you with getting into the program. Now, if you're a veteran of any one of the branches of the United States military, Jefferson County District Attorney's Office has another program that is called Veterans Court. Veterans Court is for veterans only. And with that program, if you get into the program and complete the program, they will dismiss the case and you may qualify for what is called a non-disclosure, whereby your record is sealed to the general public. Okay. This court, County Court at Law Number 2 of Jefferson County, Texas, also has a program. That is a program that God led me to start within the first 100 days of taking office. Started the program in March of 2017. The program is called the CSI program. CSI is an acronym that stands for Community Safety Initiative. With that program, the program is designed to address the issue of what is called recidivism. Recidivism is where people commit crimes over and over. And so with that program, we have partnerships with agencies in our Jefferson County area. And with that program, we are able to address needs that individuals have. So we have some agencies here today. We have Spindletop, Texas Care, and earlier we had Mr. Johnny Stewart with the Battles Intervention and Prevention Program with Family Services. But what Spindletop would do today, they can conduct a private interview, either in our jury room, at their facility, or by telephone, whichever is convenient for you. They also have the ability to do an assessment to determine what your mental health needs are, and they can develop a treatment plan for either outpatient or inpatient treatment. Now, you do not have to be incompetent or insane to participate in the program. You can merely suffer from anxiety or depression or any host of other mental illnesses. Spindletop has the expertise to diagnose and address your mental health needs. Now, if you have issues with drugs or alcohol, well, Spindletop has a program that is called ATAR. ATAR is an acronym, ATAR, that stands for Addiction Treatment and Recovery. It is a drug and alcohol recovery program. And what ATAR, well, we also have a partnership with the Golden Triangle. We have a partnership with our local drug and alcohol council that has a program that is called OSAR, an acronym OSAR, that stands for Outreach, Screening, Assessment, Referral. Both ATAR and OSAR are drug and alcohol recovery programs. And what they can do a screening, an assessment, and develop a treatment plan for either outpatient or inpatient treatment, depending on your drug and alcohol needs. Now, if you're looking for a job, or if you're looking for a better job, well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. And Lamar University has a program that is called CICE. It's an acronym that stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you're trained in any one of those areas, they will help you get a job in the area that you're trained in. If you have not graduated from high school, or if you do not have a GED, well, they have a GED program where you can receive your graduate equivalency diploma. Now, all of these programs that I just mentioned to you are free. Does not cost you anything but time. And I like to say in this court, we don't just give time, we take our time. That simply means we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I'd like to say that when you come to county court at law number 2, Jefferson County, Texas, we do not just have court as usual, we have unusual court. It's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the community, what comes out of the home goes into the community. And so if you're interested in any one of these programs, just let us know, and we can direct you to the people that you need to talk to, and we can give you brochures so that you can get started on the road to living your best life. Okay, so as I mentioned to you earlier, we have some folks here from some various agencies who participating in our CSI program. At this time, we have Caitlin and our mental health deputy, Otis Butler. They're going to come and tell you a little bit more about the program that Spindletop has to offer.
Thank you, Judge.
You are.
Good morning, everybody. I'm Deputy Mother with the Jefferson County Sheriff's Department. And I'm one of the deputies of Spindletop and the program they got going on. United Counselor, with the medication. Our part is consisting of Spindletop is to become a client with Spindletop. We're here to transport you to any doctor's appointment you would make. You would ride back from the doctor coming back home, that's what we should be. We assist Spindletop. It's another side of law enforcement. It's not to put you in jail, so we have to keep you out of jail if you become a client with Spindletop. This is Miss Caitlin. She's a Spindletop professional, and she'll tell you more about the program that's on the.
So in the front, there should have been like a little half piece of paper. That's from us. That is not a court document. You do not have to fill that out. It is optional. Anything that you put on that paper or that you talk about with us will be protected between you and me through HIPAA. I don't tell the judge, I don't tell anybody else in the court what we talk about if we talk. Like Judge said, we offer services for mental health and substance use. For mental health, we offer talking to a doctor to get medications. If you're interested in that, we have counselor options. We can help you find resources for pretty much almost anything that you can think of within the Golden Triangle, or we can try to find resources in Houston for you. If you're interested in talking about getting into Spindletop services or services, regardless of if it's Spindletop or not, you can write on your paper, please talk to me today, and when the judge is through with you, I'll pull you to a back room and we can talk privately about whatever's going on. Any questions? Okay. Yeah.
Okay, thank you, Deputy Caitlin. Now, at this time, we have Mr. David Cook and we have Darren Clark. They're with Texas Care. They're going to tell you a little bit more about their program.
Thank you, Judge. Hi, I'm David Cook. I'm the care coordinator over at Spindletop, and we've been working with Texas Care. I used to work with Texas Care as an outreach advocate. I've kind of been in your shoes. Pretty cool that the court allows the community resources in the court. I wasn't offered that option, but if I would have used it. And so community resources kind of got me where I'm at, and it come full circle. And I want to introduce one of our QHPs from North Vermont, and he will be taking over from here. And there's also a form on your clipboard if you need services. We focus on children, and I'll let him explain what he does.
Morning, y'all. My name is Darren Clark. Texas Care, we're new in town. We've been here for about 6 months. My office is right here at the Energy Building on the 3rd floor. Preferably, yes, I have been in their shoes, but also I have also been able to chance to help. I am a former juvenile probation officer, but also a former educator here in the Beaumont Independent School District. But I also wanted to start tackling and work with Texas Care that way I can start wondering how come kids and adults, mental health is real. This is a good stepping stone for if you are in the court system, to be a stepping stone showing that you are trying to seek some help. We work with any type of behavior issues, anxiety, depression, ADHD. I also got a couple of other kids with autism. Love to work with them. We have an intake packet. We can go and talk privately. We can go, Carly is my secretary. She's available if you need someone, maybe a brother or sister, niece or nephew, that you know they could possibly use our services. This will be a good, stepping stone to start receiving some help. You will not have to give your name right now. You can call us confidentially, call and get some help. This is a good little way to stay up out of the court system. Maybe sometimes people just need someone to talk to. If you need some type of help, we'll leave some literature for you to read. It's right up here in the front. Anything that you need, we're here to help you. I really appreciate it. Thank you.
Okay, thank you. Okay, so now, ladies and gentlemen, we're gonna give you some time to finish fill out the paperwork. If you need help, well, we have our court personnel, including myself, who will be happy to help you with completing the paperwork. Now, it's gonna take a little time, for you, it's gonna take a little time for you to complete the paperwork. Once you complete the paperwork, we're gonna pick the paperwork up from you. And then we're gonna go through it, evaluate, make sure everything is filled out properly. And then we're going to call you up one at a time before the bench. You're gonna be placed in one of three categories. One category, you wanna hire an attorney. And if you're placed in that category, then your case will be reset, give you time to hire an attorney. The next category is you would like to apply for a court appointed attorney. And if you're in that category, if you qualify, you will be appointed an attorney before you leave court today. All right, and then the third category is if you would like to represent yourself. You will have an opportunity to talk to the assistant criminal district attorneys. And if you're able to work out an agreement, then your case will be taken care before you leave here today. Now, as I mentioned to you earlier, it's gonna take us a little time to get all of this here done. If you need to use the restroom, there are some restrooms out in the hallway. The men's restroom is in front of County Code 1103. And on the opposite side of the hall, there we have the women's restroom in front of 172nd District Court. You will be allowed to use the restroom. And then you can come back into court. Please do not leave the courthouse. If you leave the courthouse and your name is called, and you're not here when your name is called, your bond will be forfeited. A warrant will be issued for your arrest. You'll be arrested, placed in the Jefferson County Jail, or placed in the, if you're out of county, placed in the county jail. And guess what? We're gonna have to go through this all over again. And so we're gonna try to get you in and out and in one of those categories as fast as possible. Again, if you need any help, just let us know. You can raise your hand. Make sure that you conduct yourself accordingly because we are still in court. Okay? And at this time, the court will be in recess. All right? If you need help, just raise your hand and we'll be happy to help.
What does intellectual disability mean?
It used to be called mental retardation. It's now called intellectual disability. Okay?
If you're down, I can collect it.
Anybody needs help? Okay. December the 2nd? Okay, Mr. Stovall,
Yes, sir, I'm here.
okay. Let's see. You have three cases, cause numbers 25 CCCR 0928, cause number 25 CCCR 1250, and cause number 25 CCCR 1677. Both cases are styled the state of Texas versus J. Stovall. And Mr. Stovall, is that your full name?
Yes, sir.
Okay, Mr. Stovall, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you may put your hand down. How are you doing, Mr. Stovall?
I'm doing all right. How are you?
I'm doing fine, thanks for asking. Now, Mr. Stovall, yeah, Mr. Stovall, do you have, that court date? December 2nd? Okay, Mr. Stovall, your case will be reset to December 2nd, 2025 at 9 a.m. And at that time, you're gonna have to come in court in person to fill out the paperwork. Now, if before that date, if you, for example, hire an attorney, then what will happen, your attorney is probably gonna get that case, that date reset.
Mm-hmm.
Do you understand?
I do. So does everything that you just explained to everybody else, does that not apply to me?
Yeah, it applies to you, but I'm just saying, if you decided to hire an attorney, your attorney is probably gonna get that date reset, but if you do not hire an attorney, you need to be in court to fill out the paperwork and then at that time, depending on what you choose, whether or not you want to hire an attorney, whether or not you want to apply for a court-appointed attorney, or whether or not you want to represent yourself, you'll have all of those options.
Can I not make one of those choices today?
You can, we have to make that on paper. That's why I say you have to make that on paper. We don't have the paperwork.
Gotcha. So if I were to come there before December 2nd, would that be okay?
Yeah, you can do that. Now, we usually have we have our arraignments on Tuesdays.
Mm-hmm.
Yeah, you can do it any one of those Tuesdays, you're right.
So today, this arraignment doesn't count?
No, you've been arraigned already. You just
Uh-huh.
have to come in and fill the paperwork out.
Okay, I just have to do it on a Tuesday?
We could set you on a different day. What day did we set him on?
December 2nd,
What day is that?
Tuesday.
That's a Tuesday. Did you need to set it on you can come in now. Normally, on Tuesday, we have our arraignments. On Mondays, Wednesdays, and Fridays, we have what is called our announcements.
Uh-huh. Okay. Okay, so
We could keep you on that date, but if you want to come in earlier, you can do that.
yeah, I was just hoping to get this kind of taken care of before then.
That's put it like, look at it this way. That's the absolute last day. You
Gotcha.
could come in anytime before that.
That's the deadline. Okay.
Right.
Okay. So I won't be able to make a plea or say if I want to represent myself today.
No, you can't do all of that. You have to do that in person because there's some forms you have to sign.
Okay. And those have to be signed in person.
We'll sign them in court. Right.
Okay. All right.
Right.
Okay. And so between now and then, I won't have the ability to speak to a prosecutor.
No.
Okay. Okay.
Yeah,
Understood.
they won't speak to you over Zoom anyway. So yeah.
Okay. Understood. Okay.
Right. Okay.
Understood. Thank you.
Okay. Now, before you leave, I need to give you some bond conditions. And these bond conditions are standard bond conditions, and these bond conditions are going to also be sent. I think she said she has your email address.
Yes, sir.
She's gonna email these bond conditions to you. You have 3 cases involving violation of protective orders. And so, the bond conditions state standard bond conditions in County Code at Law number 2. And it states following return of a criminal information in County Code at Law number 2 of Jefferson County, Texas. All bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, defendants shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offenses, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
Now, condition number 4 does not apply. However, condition number 5 does apply. And condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn, full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
And condition, we have listed as condition number 7, states that the defendant shall wear a global positioning monitoring system device at the defendant's expense, with written verification being submitted to the court within 3 days of this date. Do you understand that condition?
I do, but I had a question about that. So when I got released from jail, are these the same bond conditions as before when I got released from jail, or are these new?
I don't know what your bond conditions when you got released from jail.
Well, they were issued by your court.
When you got usually I
And they
issue.
waived that condition number 7 that you just mentioned.
Well, if it was issued by my court, it wasn't waived. So it might have been issued by somebody else. But let me take a look. Yeah, but no,
Okay.
that condition is not being waived. Okay? So I don't know who you talked to.
I have the
Now you was bonded, you bonded out of county, wasn't it? Didn't you? It
surety
wasn't in
bond-
Jefferson County, right?
surety bond out of Travis County. But
Okay. Oh, that's
well-
Travis County, but
well, the surety bond came from Jefferson County. And the condition, that 7th condition about the tracking device was
I don't
waived.
know. Okay, hold
I've got
on.
should I email you the paperwork on that?
No, it should
Okay.
be in your file. I'm getting ready to look at your file right now. Okay, let's see. Did you reset it already? I need to take a look at the bond conditions. Are you?
Well, what is it though? Yeah, I know what you did. So, mark that out, so this is in my. Monthly income, this is the, nice, I'll write it down. You don't name mortgage, you know,
Let's see.
you don't name
Yeah, I don't see no bond conditions in this case. Yeah, we don't have no bond conditions in your case. These bond conditions are being set today by this court, okay? So, you will be required to, adhere to all of the bond conditions that I just stated. And as I mentioned to you, condition number 7, you have 3 days to get a global positioning monitoring system device. And you need to provide proof to the court within 3 days.
3 days, okay. And how do I do that?
Okay, I mean, we have some places here, but I don't know where you're located, but we have some, there are some places here, that we can send to you when when we send these bond conditions to you.
Okay, but you said I have 3 days to get it, and then within
Send
those,
proof of it. You can email the proof that you received it from the company that you get it from.
okay, perfect, thank you.
Okay, all right. Now, again, your case is reset, your cases are reset to December 2nd, 2025 at 9 AM. And again, if you would like to come in before that date, you can do that.
Sounds good.
All right?
Thank-
So, we have your email, the reset and the bond conditions will be sent to you. You're free to go, and you have a blessed day.
You too, thank you.
You're welcome. Jefferson County Court at Law number 2 is back in session. The court is in session with the arraignment docket. Hold on a minute. First case is cause number 25 CCCR 2130. Case is style of state of Texas versus Pedro Go. Is that Mr. Go? Okay, put his telephone in his pocket. Okay, okay, Mr. Go speaks Spanish. We have Ms. Jennifer Raji, who is our translator, and Ms. Raji. Would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Judge.
You may put your hand down. How are you doing?
Good, Judge. How are you?
I'm doing fine. Thanks for asking. Now, Ms. Raji, ask Mr. Go if his name is Pedro Go. Gu?
No, it's not. It's good.
Gu?
Gooch.
Gooch. Okay. Ask Mr. Gooch to raise his right hand. Mr. Gooch, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay,
Yes, Judge.
tell him he can put his hand down. Ask Mr. Gooch how he's doing.
Good.
Good? Okay. Mr. Gooch, I have before me. You could show this to him. Ms. Araji is showing you a document that is titled Judge's Explanation of Rights of Defendants Without Attorney. Do you recognize that document?
Yes.
And is that your signature at the bottom of that document on the line that's titled Defendant?
Yes, Judge.
And are those your initials on the line that state you would like to reset your case to hire your own attorney?
Yes, this was Esta fue conocida de sus iniciales. Yes, Judge.
Okay. Now, ask Mr. Gooch if before he signed and initial signed and initial that document, if you went over that document with him in Spanish.
Antes de firmar, lo que digo a poner sus iniciales de que sí, pues, explicó lo que dijo ese documento. Yes, Judge.
Okay. And ask him if he understood everything that you went over.
Yes, Judge.
Okay. And is everything in that document true and correct to the best of his knowledge?
Yes.
Okay. Okay, Mr. Gooch, give us a reset date and the hire. Okay, this case will be reset to December 3rd of 2025 at 9 AM to give him an opportunity to hire his own attorney.
Cause he had asked me beforehand if he.
Oh, he need-
the
He needs
60
more days. I'll give him a 60-day reset.
It'll be January seventh.
January 7th.
Today. ¿Está bien? 17. 7. Sí, ok.
Okay, so his case is reset to January 7th. Tell him he can get his reset from our court coordinator. Once he gets his reset, he's free to go. Tell him to have a blessed day, and you have a blessed day as well, Mr. Roger.
Thank you.
Okay.
Ya te puedo decir que estamos
He's hiring.
pues. Sí, pero no se necesita la universidad. Oh, no. What's the news? That's just the paper. Let me scan.
Aaron F. Dressler. Would you please come forward?
Ms. Russell, you can put your purse for me on that table. Thank you.
Ms. Dressler, your full name is Karen F. Dressler?
Yeah.
Ms. Dressler, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. How are you doing, Ms. Dressler? Okay, a little bit.
Kind of new to me.
Okay, you're fair to middling. Okay, now, Ms. Dressler. I have before me a document. Well, Ms. Dressler, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
Ms. Dressler, you may put your hand down. Now, Ms. Dressler, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
It's my signature. It's the one I just filled out.
Yes. Okay, so you recognize it, okay.
Yeah.
Are these your initials on the line that state you would like to have your case reset or hire your own attorney?
I would like to.
Okay. Now, Ms. Dressler, before you sign and initial this document, did you read the document?
Did I read the whole thing?
The document that I went over.
Yeah, you went
Okay.
over it. Wayne.
And did you understand everything that we went over?
Yeah.
And is everything in this document true and correct to the best of your knowledge?
Yes.
Okay, Ms. Dressler, your case is going to be reset. Give us, our court coordinator is going to reset your case to give you an opportunity to hire your own attorney. Once your case is reset, you'll be free to go and you have a blessed day.
May I ask you a question?
Yes,
Wonder if it's not enough time. I just got in a bad wreck and I had to get another car. And it's just too much for my brain. I need to see about getting on medicine, so.
okay. Well, what she's gonna do, give us 60 days.
That'd be January. I really
Okay.
appreciate it.
Okay, you're welcome. Now, Ms. Dressler, your case will be reset to January 7th of 2026. Once you get your reset, you'll be free to go and you have a blessed day.
Thank you, sir.
You're welcome.
But I need one more question.
Yes.
I mentioned something about these people in spending time.
Hold on, let me do this here.
They got our Thank you.
Next case is cause number 25 CCCR 2208. Case is styled State of Texas versus Justin Savage.
I know I was locked, Mr. Esselman.
Mr. Savage, your full name is Justin Lee Savage?
Yes, sir.
Mr. Savage, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Sure.
Mr. Savage, you may put your hand down. How are you doing, Mr. Savage?
Pretty good, how are you?
I'm doing fine. Thanks for asking. Now, Mr. Savage, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line?
Yes, sir.
That's titled defendant. Are these your initials on the line that
Yes,
state
sir.
you'd like to apply for a court-appointed attorney? Now, Mr. Savage, before you signed and initialed this document, did you read the document?
Sure did.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Savage, your case will be reset to give you an opportunity to hire an attorney. Our coordinator is going to reset your case. Once your case is reset, you'll be free to go.
Yes, sir.
And you have a blessed day.
Can I get a 60-day reset, please?
Okay,
Okay.
okay. Okay. All right, you can give you a reset. Once you get your reset, you're free to go. You have a blessed day.
Thank you.
All right. Luis Gamaz. Okay, this is cause number 25 CCCR 2166. Case is styled State of Texas versus Luis Eduardo Gamaz. Mr. Gamaz, is that your full name? Mr. Gamaz, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Gamaz, you may put your hand down. How are you doing, Mr. Gamaz? I'm doing fine, thanks for asking. Now, Mr. Gamaz, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled defendant?
Yes.
Are these your initials on the line that state you would like to apply, excuse me, that you would like to hire your own attorney? Now, Mr. Gamaz, before you signed and initialed this document, did you read the document? Did you understand what you read?
Yes.
Is everything in this document true and correct to the best of your knowledge? Okay, Mr. Gamaz, your case will be reset to give you an opportunity to hire an attorney. Once your case is reset, you get your reset from our court coordinator and you'll be free to go and you have a blessed day. Please have a seat in that first chair on the wall.
Thank you.
DeAndre Williams. Mr. Williams, your full name is DeAndre Jordan Lynn Williams. Mr. Williams, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Williams, you may put your hand down. How are you doing, Mr. Williams? I'm doing fine, thanks for asking. Now, Mr. Williams, I have two documents before me. The first document is titled Judge's Explanation of Rights to Defendant Without Attorney. And do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you like to apply for a court-appointed attorney? I have another document that is titled Jefferson County Affidavit of Innocence. You recognize this document? On page 1.
Thank you.
And on this third page, is this your signature on the line that's titled defendant?
Yes.
Now, Mr. Williams, before you sign and initial these documents, did you read the documents?
Mhm.
Did you understand what you read?
Mhm.
And is everything in this document true and correct to the best of your knowledge? Okay, Mr. Williams, I read your answer. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Nicholas Jeter. Attorney Jeter will be given information to contact you. And you will be given information to contact him. Our court coordinator will give you that information. And once she gives you that information, you'll be free to go. You have a blessed day. Please have a seat in that first chair on the wall. Nathan Wayne McDaniel. Mr. McDaniel, your full name is Nathan Wayne McDaniel?
Yes, sir.
Mr. McDaniel, would you please raise your right hand? Mr. McDaniel, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth shall be God?
Yes, sir.
Mr. McDaniel, you may put your hand down. How are you doing, Mr. McDaniel?
Doing fine.
I'm doing fine. Thanks for asking. Now, Mr. McDaniel, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled defendant? Or are these your initials on the line that state you'd like to apply for a court-appointed attorney? I also have another document. Hey, Ms. Bosby.
Yes.
This one only have 2 pages on this one. I need the page that I signed for the appointment.
With the last 93, 93.
Okay, thank you. Now, Mr. McDaniel, I have before me a document that's titled Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature on the line that's titled Defendant. Is this your signature?
Yes, sir.
Now, Mr. McDaniel, before you sign and initial these documents, did you read the documents?
Yes, sir.
And did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay. Okay. Mr. McDaniel, I read your answers. Based on your answers, you meet the eligibility requirement for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Jack Lawrence. Attorney Lawrence will be given information to contact you. And he will be given information, and you will be given information to contact him.
Yes, sir.
The court coordinator will give you that information. Once she gives you that information, you'll be free to go.
Right.
And you have a blessed day. Please have a seat in that first chair on the wall.
Thank you.
Oh, let's see. Jorge Luis Cruz Hernandez. Mr. Hernandez, your full name is Jorge Luis Cruz Hernandez.
Yes, sir.
Mr. Cruz Hernandez, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth,
Yes,
and
sir.
nothing but the truth so help you God?
Yes.
Okay, Mr. Cruz Hernandez, how are you doing?
I'm good, man. How are you?
I'm doing fine, thanks for asking. Mr. Cruz Hernandez, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes.
Is this your signature on the line that states you'd like to apply for court-appointed attorney?
Yes, sir.
Well, this is your signature on the line that's titled defendant.
Sir.
And these are your initials saying you want to apply for court-appointed attorney. Is that correct? I also have another document that is titled Affidavit of Insurance. You recognize this document?
Yes, sir.
On page 2 or 3 of this document, there's a signature above the line that's titled defendant signature. Is this your signature?
Yes, sir.
Now, Mr. Cruz Hernandez, before you sign and initial these documents, did you read the documents?
Yes, sir.
And did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Cruz Hernandez, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in your cases is Attorney Todd LeBlanc. Attorney LeBlanc will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. But before she gives you that information, I need to give you, the bailiff is going to give you some bond conditions that I'm going to go over with you. And that document that you have in your hand is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that title?
Yes.
And it states, following the return of accruing information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named here and are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? That's number 1.
Yes.
Do you understand that condition?
Yes, sir.
Okay, condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
Okay, and condition number 3 and 4 does not apply. However, condition number 5 does apply, and it states that the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. You understand that condition?
Okay.
Okay, now, Mr. Cruz Hernandez, if you violate any one of these conditions, your bond can be revoked, and if your bond is revoked, warrant will be issued for your arrest, you will be arrested and placed in the Jefferson County Jail. Now, Mr. Cruz Hernandez, you're gonna have a seat in that first chair, wait for your name to be called. Once your name is called, you get your reset and you're free to go, and you have a blessed day.
Thank you, sir.
Oh, Anthony Elias. Okay, for the record, your name is Anthony Elias?
Yes, sir.
Mr. Elias, would you please raise your right hand? You swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Elias, you may put your hand down. How are you doing, Mr. Elias?
Doing good, much, sir.
I'm doing fine, thanks for asking. Mr. Elias, you are, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants by Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Initials. You recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature on the line that's titled Defendant. Is that your signature?
Yes, sir.
Now, Mr. Elias, before you sign and initial these documents, did you read these documents?
Yes, sir.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay. Let's see.
Frozen on there. The attorney's name is Carl, it's court date, December 17th. We should be contacting the prevention companies, I am, if you have any questions before the court date. Thank you.
Okay, now, Mr. Elias, I read your answers. Based on your answers, you do not meet the eligibility requirements for the appointment of court-appointed attorney.
Is that what?
You do not meet the eligibility requirements for the appointment of a court-appointed attorney. I know I see here you added up your expenses wrong, so I added it up again. Okay, so you're going to now you have two options. You can have your case reset to hire your own attorney, or the second option, well, the next option would be you can waive your right to attorney and represent yourself. Now I'm going to hand this document back to the bailiff. She's going to hand it to you so you can sit down at the table. You make your choice. Okay, so now your case is going to be reset to give you an opportunity to hire an attorney. Okay. Our court coordinator is going to reset your case. Once your case is reset, you'll be free to go. And you have a blessed day. Please have a seat in that first chair on the wall.
Appreciate it.
All right, thank you.
60 days.
Can you get Victor Asia?
Yeah, you could give it to him. got an error coming up. Trying to open up this document. I was having problems opening up, but just try it.
Is that what you want?
Yeah, let me see if I can do it again.
You know, these are-
Same thing, yeah, we need yours.
This would be the other two we're looking. Because, but you're looking.
Here, it's one.
Okay.
Octavian DeMarcus Evans. Ms. Evans, before we get started, you have a right to have a court reporter to type down everything that's being said. You also have a right to waive or give up your right to have a court reporter. Do you waive or give up your right to a court reporter?
Yes, sir.
Okay. Now, Mr. Evans, would you please raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Evans, you may put your hand down. How are you doing, Mr. Evans? I'm doing fine, thanks for asking. Now, Mr. Evans, state is represented in this case by Mr. Samuel Masradian. Mr. Masradian, how are you doing?
Doing well, Judge. Thank you.
And Mr. Evans, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes,
And is this your signature on the line that's titled Defendant?
yes,
Or these are initials on the line that state you like to waive your right to an attorney and represent yourself?
yes,
I also have another document that is titled Waiver of Counsel for Purpose of Inter Guilty Plea Proceeding to Trial. You recognize this document?
yes,
And is this your signature on the line that's titled Defendant?
yes,
I also have a document on my computer that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Octavian DeMarcus Evans, on or about January 31st of 2024, while you were in Jefferson County, Texas, that you committed a Class A misdemeanor offense, criminal trespass to an infrastructure. Do you understand what you've been charged with?
yes,
And to this charge, how do you plead? Guilty, not guilty, and no contest?
no contest.
Are you pleading no contest freely and voluntarily?
Yes,
And are you pleading no contest because you do not wish to fight or contest the charges?
yes,
Mr. Evans, I also have before me a document on this tablet that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes.
On page 2 of this same document, there are two sets of initials. First set of initials is below a paragraph that is titled waiver, and the initials are on a line next to a box that's checked no contest, or no contendere, which means no contest. Did you place your initials in this location?
Yes.
Second set of initials are below a paragraph that is titled discovery admonishment, and your initials are next to a statement that states, I do not request discovery. I waive my right to discovery in this case and choose to enter a plea of guilty or no contest. Did you place your initials in this location?
Yes.
On page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes.
On the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes.
And is this your signature? Well, are these at the bottom of this document? There's a signature above the line that is titled defendant. Is this your signature?
Yes.
At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
Now, Mr. Evans, before you signed and initialed all of the documents that I showed you, did you read the documents?
Yes.
Did you understand what you read?
Yes.
Is everything in these documents true and correct to the best of your knowledge?
Yes.
And Mr. Evans, are you a citizen of the United States?
Yes.
State offers States Exhibit 1, Your Honor.
Okay, now, Mr. Evans, the state is offering States Exhibit number 1 to be used as evidence in this case. States Exhibit number 1 is the first document that I showed you on this tablet. It's the same document that you said that you recognize. It is the same document that have your initials on page 2, the two locations, and it has your signature on page 3. Is it all right for the state to use this document as evidence in your case?
Yes.
Okay, no objections. States Exhibit number States Exhibit number 1 will be admitted. I may have to send this back to you, and it's gonna send it back to me. Man, this whole thing went out. It just came up.
Just get to.
I sent it to you. I don't know what happened.
Yeah.
Hold on, wait up. I got it back. Okay, send it back to me. Okay. Okay. Yeah, I have it. Okay. Now, Mr. Evans, is there any evidence that you're currently mentally incompetent to stand trial? Okay. Mr. Evans, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in this case?
We do, Your Honor.
And what's the agreement?
That would be 6 months deferred adjudication with a $300 fine and 30 hours of community service plus court costs.
What's the court cost?
190.
190?
Yes, sir.
Okay, Mr. Evans, the state is offering that you serve 6 months deferred adjudicated probation. During the 6 month probationary period, you'll be required to pay a fine of $300 plus court costs of $190. You will also be required to pay a probation fee of $60 a month, year analysis fee of $15 a month, reimbursement fee of $15. Your total monthly installments is $191 a month. Will you be able to pay the $191 each month?
Yes.
But you will also be required to perform 30 hours of community service and adhere to the other standard terms and condition of this probation. Now, Mr. Evans, do you understand the state's offer?
Yes.
Do you think that the state's offer in your case is fair and just?
Yes.
Do you accept the state's offer?
Yes.
Mr. Evans, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Mr. Evans, if you successfully complete this probationary period, this case will be dismissed. It will not result in a conviction on your record, and you may qualify for non-disclosure. You can talk to an attorney about the non-disclosure. And now, Mr. Evans, this will conclude your case. You're gonna stand next to the bailiff, follow her direction. Once you finish following her directions, you're free to go.
Yes.
And you have a blessed day.
You too.
Thank you. Tyler Whitney Gobar. Okay, Mr. Gobar. Your full name is Tyler Whitney Gobar.
Yes, sir.
Mr. Gobar, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Gobar, you may put your hand down. How are you doing, Mr. Gobar?
I'm good.
I'm doing fine, thanks for asking. Now, Mr. Gobar, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that states you like to waive your right to attorney and represent yourself? I also have another document that is titled Waiver Counsel for purposes of entering a guilty plea or proceeding to trial. You recognize this document?
Mhm.
And is this your signature on the line that's titled Defendant? Now, Mr. Gobar, before you sign and initial these documents that I just showed you, did you read the documents?
Mhm.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes.
Okay, now, Mr. Gobar, I see here that you wanted to waive your right to an attorney and represent yourself. Is that correct?
Yes.
Now, have you talked to the state?
I did was.
Okay, so,
So we would like to ask for a reset so we can get in contact with the complaining witness. We've set up a date and time for him to come into the office after that point, about 2 weeks from now. So at that point, we can give him the plea offer. Before then, we would need to speak.
okay, this is a death case?
Yes, Your Honor. We
Okay,
need to confirm the restitution now.
okay. Okay, give us a reset date. Say gonna reset 2 weeks. Is that correct? That's what you,
We
what,
had the date for him to come in 2 weeks on November 11th.
oh, okay. We got standard reset.
Yes, please.
I'm keeping them on the Raymond docket, or I'm putting them on announcement.
Oh, you can put him on an announcement. He doesn't have, yeah.
Okay. That'll be December 3rd.
December 3rd of 2025. Okay, Mr. Gobar, your case will be reset to December 3rd, 2025. Give the state an opportunity to get with the complaining witness in the case. And you can get your reset from our court coordinator. Once you get your reset, you're free to go, and you have a blessed day. Oh. Mm. That lawyer, I think the lawyer for Justin Woods, when I was doing the arraignment, he had came in, he was in the back of the courtroom.
Yeah, he said on the felony.
Oh, the felony this afternoon? When is the felony set?
Felony was said today, that's why he's on the docket.
Oh, that's right. They said that, I guess they're in trial and
Yeah.
when they have a break, it was gonna get, yeah, they're gonna get to him on his case. Okay. Now, Leon's, Monroe, that was reset?
He said that, no, he said that, to December 2nd.
What he had, he had a,
there, you want me to come over, set up, home?
hmm?
If he's still out there,
No, he should be gone.
that attorney?
That was.
No. We talking about somebody else. You talking about Woods? I think they may be disposing of a felony.
No, Wood is next door.
I know, what I'm saying, they're gonna be
Yeah,
disposing of that felony
whenever they have a break.
when it's at some break. Yeah, but, you can probably get with him and find out what the plans are in the felony case. I don't know if they're disposing of I doubt if they're disposing of this misdemeanor in that felony case.
No, that makes it.
Okay, Hernandez was reset, was appointed. Hernandez. Okay. Ariana Wilmore's name was just called again at the courthouse door. Ariana Wilmore did not answer. A reasonable time has passed to give Ms. Wilmore an opportunity to appear in court. State, do you have a motion?
State moves for bond forfeiture, Your Honor.
That motion will be granted. Ariana Wilmore, bond will be forfeited, and a warrant shall be issued for the arrest of Ariana Wilmore. And this will, we still have one case left on the docket, Justin Woods.
Yeah, they just broke for lunch, but I didn't see that one, you.
Okay, so, the court will be, I guess, recess for lunch. Okay, so we'll be back at 1 o'clock.